here on time. I apologize for the delay to the committee members and those that might be watching us. We'll go ahead and settle in as the last item is handed out. Call this meeting of the higher ed House Higher Education meeting to order. And again, thank everyone. I know we have some folks online. Let me pull everybody up so I'm not missing anybody either. Okay, the goal this afternoon is to introduce back to the committee some information about House Bill 1, House Bill 120, and House Bill 291. We have substitutes for those for a variety of reasons that we'll speak to. The chair is not inclined today, unless it's just somebody has something on their heart to take additional testimony today, but instead to spread these bills over the committee for their information, give you a day or two here to look at them and reconvene for the committee to take possible action. So with that, and knowing we're on a short time frame, I'm going to go to Representative Bonner, if you would talk to us. Again, we know the crux of the bill, but if you would explain to the committee the work you've done and what modifications have been made to the measure since we last saw it. And I guess since we last saw it, and also related to the language that this committee passed last session. So.
We on? Okay. So to the committee, what we will be discussing today is LC 490467S. The committee substitute. So what we did, Mr. Chairman, upon your after the last hearing and upon your guidance, we tried to work out and kind of massage some of the language that the members had issues with, and primarily those issues revolved around the association clause. And so we had reached out to USG and got some feedback from them, and reached out to the ACLU policy folks and got some feedback from them. And unfortunately, we just weren't able to come to what we believe to be a good solid agreement on that. So what we decided to do was to remove that portion from the bill. So in the previous bill, that was lines 102 through 110, and then 234 through 242. We simply deleted those. And then in addition to that, Mr. Chairman, we removed the cause of action portions as well. That was on lines 120 to 134, and then 252 to 266. So that essentially is the major changes to the bill, Mr. Chairman. As we had mentioned previously, those items that remain are those related to the speech codes and the speech zones. And we had went back and looked at that language again, just to make sure that from our standpoint, it was consistent with case law and definitions that out there. And so those were what we stuck with on that. But those, Mr. Chairman, are the primary changes, and I'll be happy to take any questions from the committee.
Thank you, Chairman Bonner. And does the committee have questions? Commissioner, yes, ma'am. Press the button that you have in front of you. Okay. Yes, ma'am.
Oh, okay. Thank you, Mr. Chair, and thank you, Representative Bonner. I know that you said that you some of the language that you left in is from case law, but I still have some concerns because I know that we changed a few lines, specifically the definition of materially and substantially disrupts. We originally took out knowingly and intentionally in 2020, and that language was added back. And on line 56, the definition of student harassment, it says severe, pervasive, and subjectively and objectively. We had removed that language in 2020, and it was also added back. And then on line 80, under protected expressive activity, subsection E, we had added language protected by the First Amendment, protected expressive activity protected by the First Amendment, and in this version, that language is removed. And so I am wondering about those three sections on why we did not choose to stick with the 2020 version of this portion of the bill.
Sure. Thank you for the question. So as I mentioned previously, of course, I didn't get a vote in that committee hearing as I wish I possibly could have. So what came out of that committee, while we appreciate the work that was done, we, in the interim went back and just reviewed and just to make sure that from our position and what we deem to be consistent case law and jurisprudence, went back and just adjusted those definitions back to what we believe is consistent with those court cases. And so that was our decision-making process on that.
All right, thank you.
Dr. Clark, and we can, for the Friday meeting, I'm not sure we have them on line now, but I think the committee would gain from the testimony of the attorney from the university system. They have reviewed this language, and I think maybe some things have happened with case law between them that am I not correct in saying that they have reviewed this current language? Representative?
They had provided some feedback on the materially and substantially language. Again, from our position, it comes down to just essentially interpretation by attorneys as to what is case law, and so we reverted to what we believe to be case law.
Okay.
We did send this version, Mr. Chairman, to USG, and what we believe to be their most pressing issues were the association clause and the cause of action. And so that's why we decided to simply remove those to accommodate that request.
Okay, thank you. Further questions? That's good question, Representative. And we'll get USG to do that, and we can get for the other members. You did a great job of pointing out some of the changes. I have a red line between this version and the one we passed, but we'll continue. And thus the reason I wouldn't ask you to take action on it today by just getting it today. If there any further questions, any questions virtually from the virtual world out there? Okay, if there are other finds or other catches, please get them to us, and we'll work on moving forward later in the week. Thank you.
Thank you, Mr. Chairman.
Thank you very much. The next item we're going to go to, and I'll do it quickly. Representative Carpenter is tied up in another committee meeting, so I'm going to, if there's not objection, since we're not taking action, I'm going to present the changes to 120 from the chair. Again, since I won't be refereeing, if you will, or presiding over a debate on any action, I won't yield the chair at this point, but instead talk to you about House Bill 120. House Bill 120 as a substitute essentially gets the action that the representative was looking for previously, with some new definitions. And I'm going to slip this down. I think I'll maybe can hear me a little better, with some new definitions to make it clearer. And it also does that without specifically invoking in-state tuition. The idea of the bill as a substitute is to bring three options for opportunity together. The opportunity as a student to attend and have access to an opportunity tuition set by the TCSG board via a tuition factor, which I'll explain later, and the opportunity of the university system or the TCSG board to use seats that would not otherwise be filled. Draw your attention to line 16 through 19 that defines what an eligible unit of the university system is. That is all units except research units and units that have for the most two recent academic years had to turn away qualified applicants. So any other unit of the university system would be an eligible unit. An opportunity student, it's, I won't read those. It's clear to what the definition one has to meet to do that. Specifically, draw your attention to lines 38 and 39, where the individual has to be a verified recipient of the Deferred Action for Childhood Arrivals from the Department of Homeland Security. That was mentioned in our last hearing. It has to be a verified recipient, not someone that meets the criteria. The rest of the criteria are the same. The opportunity tuition is derived from an opportunity factor by eligible unit, so that we would allow the Board of Regents to set a factor that would be multiplied times the out-of-state tuition in order to get at an opportunity tuition that can't be lower than in-state. The idea, if there would be, if there are seats available and driving out-of-state tuition down with a factor to in-state or to within $10 or 2% or 10% is what they can do to give the university the opportunity to use that seat and not put a burden on the taxpayer, that we allow them the flexibility to set that. We've spoken with the university system and they can do that. Then I draw your attention specifically to lines 62 through, I'm sorry, lines 71 through 75 of the bill that makes clear that the university will give priority enrollment to applications from students that are classified for in-state tuition. This is already a rule in the university system. It goes to, without getting legalistic about it, it goes to something that the Attorney General has ruled on and something that they need to do. But we had feedback from speakers in the past that they were worried about this could displace students that were in the state with lawful presence or legal presence. I'm not sure what the term of art is there, but this makes it clear that students that can be classified for in-state tuition have priority. I could go through the same portion for TCSG. The operative difference is instead of eligible unit, it's eligible program, because every unit of TCSG, they do not turn people away. Instead, they have programs that are sometimes full, and to keep with the rules that they already have in place, we let opportunity tuition be available in the TCSG in the TCSG system for eligible programs. So in essence, and I'll take questions, but in essence, if this bill should pass, if one cannot gain entry to the university system or TCSG because of one's status today, this could pass and you still would not gain entrance. This simply says if you can gain entrance and you do not displace or supplant a person eligible for in-state tuition, you get access to opportunity tuition, which would be set by the TCSG board or the University System of Georgia. Again, leveraging the opportunity of the university to sell the seats, the opportunity of the student to go, and the opportunity of the respective boards to set that factor and set the cost in a manner that would make sense for the student, the university system, and the taxpayers of Georgia. I hope that I did the best. I see I have two questions. I'll do my best. Yes, ma'am.
Thank you, Mr. Chair. Thank you for the changes in the bill. I just have two questions. The first one, by adding line 38, do we need the language in line 32 that uses a specific date? Because it was my understanding by the author of the bill that the reason why he chose that was specific date was to align with DACA. But if the bill just straight out says verified recipient of DACA, do we still need this 8-year language that will continue to increase every single year? And then my second question is for lines 71 through 75. This is just a curiosity question. Does USG prioritize in-state applicants over out-of-state applicants in the process of accepting students at their schools? Thank you.
Okay, I'm going to do the best at my memory. I'm going to go back and do the first in, first out there. To answer your question on 36 and 35, I'm sorry, 31 through 33 being necessary, I think in some cases that is a belt and suspenders thing. I think that can overlap, but Representative Carpenter's original point of defining January 1st is to set a point so that this could not be seen as attracting, this was taking care of the Georgians that were here and not attracting people to move to Georgia to take advantage of it. So while I agree with you, that is when, that is when some of the people, the individuals that became verified recipients, if you were to omit 31 through 34, a verified recipient of the Deferred Action of Childhood that was not in Georgia at that time could move to Georgia, graduate from a Georgia high school having only attended a month and have access. So to answer your question, that's a policy decision for the committee to make, but they overlap in some cases. In some cases, they do not. To your second question, line 71 through 75, I'll have to get I'll let the university answer that for us when we next meet specifically. But I do know in certain cases, there are ratios they do keep with in-state and out-of-state tuition. And again, as relates to this, where we would be providing tuition availability, what this does is codify what they have in a university rule now. By rule, they do not allow someone that is even paying out-of-state tuition, a DACA student, if I can use that shorthand, could get into universities now, but they cannot do that in a place where it would circumvent or supplant, I guess is the proper word, an in-state tuition. So that's in rule. I think since we're allowing more benefit, if you will, with this bill and statute, it's important to put that into rule. Number 8.
Thank you, Mr. Chairman. I had a question regarding lines 43 to 51 regarding this creation of opportunity tuition. One, I'd like to get a better understanding of what that amount would be, or if it's kind of subjective based to various factors USG would take into consideration. But essentially, would this or permit, let me pause there. Would opportunity tuition potentially be the same as out-of-state tuition?
Well, to answer your question, it could be, but it could also be the same amount as in-state tuition. The idea is that would be set through the opportunity tuition factor on an annual basis by unit, so that it gives them the opportunity. I think part of what we heard before and what there's varying, there seems to be varying opinions on court and the definition of public benefit is, how much can or how much of the state taxpayer money, goes toward this. This gives the university system and the technical college system an opportunity to balance that, to provide, if I were to use the airplane analogy, it allows them to sell the seat at the price that would allow, the person to travel and get what they needed, and the airline to cover their cost and for flying that person. So in an educational system, it would allow the university to set, or the university system to set the rate and create a tuition that covered the cost, the incremental cost, so that the taxpayer wasn't upside down, as with in-state tuition. And then that could vary by institution and by academic year. But it is not the intention of this bill to look to be a, for lack of a better term, bait and switch. So look, we've done something here, and I expect the tuition factor to yield out of state tuition. That is not what the chair expects to happen. There are places now in the university system where we have border waivers, where we allow through a waiver program, folks from out of state to pay in-state tuition because it is better for our university to have people in those seats and participating in the program to spread out the overall cap cost with that additional tuition they pay. So it's better to have them in there for the university system. And I would hope, Representative, that's what this would be.
Thank you, Chairman.
Just to be clear, this is not a place where we're trying to set something and then, count on it being like we haven't made a step forward. We are running the lowest time, but I got one more question. Yes, ma'am.
Thank you, Mr. Chairman. I just wanted to make a quick comment because I appreciate the changes in this bill and that we're still giving these students a consideration. I just want to say that when we talk about taxes, we got to be very clear. These families and these students and their families already pay Georgia taxes, so it's not that they are not paying taxes. So with this bill, we're not giving a benefit to people who are not taxpayers in Georgia. That is correct, right?
Sure, each individual situation is different, but clearly if you're in the state of Georgia and you're buying things, you're paying sales tax and so forth. So yeah,
working
you're
there,
correct.
So, and the other question, I had it to line 71 to 75. I just need some clarification. So basically, we're making sure, or with this bill, we're making sure that DACA students or these opportunity eligible students would basically come at the bottom of the pool for eligibility. Is that what I'm standing correct? So regardless of their academic standing or anything?
Well, yes, ma'am. That's by rule what happens in the university system. I see somebody in the audience. Am I correct, Ms. Altman, in saying that?
Sure. Thank you, Mr. Chairman. My name is Casey Tierno with the university system. So currently the rule that Chairman Martin is referencing is our 3 selective institutions that currently do not accept all qualified applicants. So that's where it's competitive to get into those 3 schools. All the other institutions within our system admit all qualified applicants currently today.
Yeah, basically, except for the research, as she said, what we're doing, Representative, is just putting this in statute. There are members and members of the public that worry about supplanting people. I don't think that will take place. I don't think that will ever exist in the real world. If it should, then I think this is a safety net, because again, a debate for a different place, and not as I've said many times, I don't want to get have the immigration debate in Georgia House Higher Ed, but that takes us out of that debate because it's not up to us to decide, what lawful presence is. But I think we need that in there to, provide the clarity and the direction. If there are no questions, I'll allow everybody to look over. Certainly, I will encourage everybody to look over that and allow questions at our next meeting. But if you would look that over, and if you have opportunities for improvement, the chair is open to that. The last one, and we do not have the author here to speak to us, so I'm just going to. Well, we're out of time though. Chairman Dempsey, I'm going to just spread this out and do a real quick, and I'm going to ask you back on Friday to answer questions. We have a substitute to 291, House Bill 291. This was working on the tuition equalization grant for nursing, and she has tightened the language down. We wanted to be very careful with that. So I'm going to let you all look over that. We have to give the room up here in 2 minutes. Oh, we have the room. Okay, I apologize. Then if you can hold with me, I want to go to Chairman Dempsey. Can you give us a quick overview of your changes? Chair Lady Dempsey. Chair Lady Dempsey, are you there? You're still on mute.
Yes, I'm sorry.
There you go.
I'm sorry, I was out of the room talking on the budget. I'm sorry, what are you asking me for? I apologize.
Okay, can you just give us, we're running short of time here, folks. But can you just tell us real quickly what you did with your substitute? I think you just tightened the qualifications for.
Well, we did. We actually have two different potential substitutes. I'm sorry. I thought we were doing this on Friday. I do apologize. So,
Chair Lady Dempsey, let me just say this. We have the one substitute we have out is 0465S. It's the one that limited the to nursing.
yeah.
That.
it
So and
did.
if you,
It did.
I'm fine at this point if we've caught you, because I know you're multitasking over there. So if you weren't planning to do that, I'm going to just go back to where I was before I thought you weren't on, and let the committee have this for review, and we'll give you a few minutes to talk to it when we meet on Friday.
That would be great and very helpful because I misunderstood the
Yes,
direction.
ma'am. No, yes, ma'am. No, consider it done. I have, thank you very much. All right, for those online and the committee here, you do not have this bill with you, but we will mail it out. It was first read this morning. We will hear it after, we will hear it at the end after the other bills on Friday. We'll get it out to you. It's House Bill 617. I'm sponsoring the bill along with Trey Rhodes, Representative Fleming, Representative Chairman Smyrie. This is referred to commonly as the NLI bill, the Name, Likeness, Image bill. There's a situation going around in college sports about what will happen, moving forward with these athletes. Should they or could they be compensated for their name, likeness, and image? And if I think several things may need to happen with the NCAA and maybe even at the national level, but we need to be prepared so that our athletes are not at a disadvantage. So I would ask you again, we wouldn't be in a position to take action on this on Friday, but we'll get the bill out to you, and we will be looking at that. It may be something we need to really focus on and work on. Came up late, but we may need to try to get that crossed over. So I spread that on you for your attention. House Bill 617. So if there's no further business, I really thank the committee for waiting on me. I had to visit with the speaker for a moment, and I appreciate everybody doing that. We will look to reconvene Friday at 1. I hear that Friday at 1 o'clock, 6:06. Thank you very much. If there are no further business before the committee, will stand adjourned without objection, and we are adjourned.